Yes.
So, welcome everyone to the last of our regular sessions in IP law, which has come around very quickly. I will be available next week in terms of people who have questions about the assignment and so forth. So I will make sure I'm available and online, and if no one logs in, but if you have questions and you want to talk about stuff, I'll be available. If you've submitted assessment and I haven't marked it yet, let me know and I'll make sure I get onto that, because Moodle has decided that it's not notifying me of anything because it's on a bit of a strike, I think. But I'll make sure I get in and try and find everything from previous tutes that hasn't been marked this week and make sure that's updated. Also, the Have Your Say red button is activated, so please jump in and give me some feedback on the course. And while you're at it, also please, once the course is over, if you're concerned about, please give me some feedback personally as well. And if you're worried about, I don't know, me being angry about your feedback or whatever, you can always do it after the grades are finalised, in which case it doesn't matter. But honestly, it's a lot easier to have a conversation about some of these things. And at the moment, I'm designing the e-law subject, and I would like to design something that matches, some of you are going to be doing it, some of you won't be, but I'd like to be designing something that works to your preferences, because as you no doubt know, this is a very, very different sort of law program, and having this just been here about 8 months, I'm only just getting the feel for what sorts of things we can do, what sort of things people want. So I'd like to do something really exciting with e-law. At the moment, there are no textbooks that are current, and I would like to do something really interesting in terms of maybe developing a wiki and have the subject less of a sit and listen and more of actually getting involved in designing and creating. If that's the sort of thing that you're interested in. But by all means, if you'd rather just sit down and listen to a course, give me that feedback as well. But yes, it's on my mind at the moment, because with e-law, I have to start developing e-law now, and I need to sort of think about what would people like to do, what are people interested in. So anyway, so that's, I think, all the housekeeping. And I'll hand over to the presenters. Yeah, okay.
All right, thanks, Scott. Kate, do you have any particular, do you want to go first, or?
I'm still trying to figure out how to get my PowerPoint to come up in the tutorial. So
okay.
If you want to go first.
I'll go then. I'll just see if we go. Just to set the scene for people, what I did for this workshop, the question asked that we developed some creative way of working with a target group around Creative Commons. So what I've put together is a short PowerPoint along with a video. I went down and I spoke to a local artist. I'll just turn this on. I spoke with a local artist and just got some feedback from him about what he saw copyright as being, and I just want to explore that a little bit more, particularly in terms of his role as an Indigenous artist, and that's the tack that I'm taking with what I'm presenting tonight. So I'll have a go at the screen sharing, and we'll just see how we go. Well, first of all, I might just start with the video. It's just a short one, and we'll just run that now.
We've got one of our local artists here, and we're just going to have a bit of a talk about his work and about copyright. So we just want to let people know your name and what you do.
James Waterton, youth support worker at the Rock. Just a local artist in Rockhampton. Been doing it since I was a little boy. It was passed down from my dad, so just trying to continue our tradition.
Yeah. And what are you doing here today?
Our art program, just young boys just teaching them how to do all the symbols and what the symbols mean. Just trying to pass it down to them too.
And how do you protect your work,
Can people hear this?
in case you do some work and other people might pass it off as theirs? Have you got any thoughts, or have you ever thought about copyright of your work?
I never thought about copyright. I've had a few people talk to me about protecting my work.
Yeah.
Because I've got a page on Facebook, and they say not to put it up on Facebook because of copyright.
Yeah.
And people might steal my stuff. So
Yeah.
Okay, so can people hear me back again?
Yep.
Okay, so I just wanted to just briefly have a talk with James, and I think this is common with a lot of the people that I know around here locally in terms of their knowledge about copyright and the things that they do to protect themselves. And I'll go through with the PowerPoint and just talk about some of those issues that have arisen with copyright and what Creative Commons can do. After researching for this particular workshop, I've changed my mind a little bit about Creative Commons. I had a view initially about greater good, but after doing some of the readings, just looking at what it is that Creative Commons do, and does it adequately address the needs of particularly Indigenous artists when we're talking about things that may be in the public domain. So are people right for me to just go on and do the PowerPoint? Is that okay? All right, we'll see how we go with this then. So after talking with James, who featured in the video, and some other artists, we just looked at why they do create what they do. And particularly with these guys, it was about telling the story and the cultural aspects of it. And one of the things that we know about copyright is that it looks at the individual, but not so much the communal rights of the art, of the people involved.
Yeah, we don't have the PowerPoint, Margaret. We just have the window again.
So can you see the slide why I create art?
No. Maybe you can stop sharing and then start sharing again and select the...
Oh, okay.
Yeah, try that.
Yeah, okay. Can you see it now?
Yes. Brilliant.
Okay. All right. So I said, talking to people about why they create what they do, and particularly with the artists I spoke to, it was really a lot about cultural connection. And you heard James say he's passing on a tradition that his father taught to him. And with copyright, I don't know what that noise is either, sorry. With copyright, it's really concerned with the individual's right and not the communal rights, which we see a lot in, particularly with Indigenous art. We just looked at what, and this is the kind of thing I would put together as a legal person for a group of artists or a couple of artists or a family group who are wanting to know a little bit about what copyright is. And so, as we know, it covers the work of the individuals and not the communal rights. It covers the work created by individuals living or recently deceased within 70 years. And the issue of that was, how does that work pass on to generations of the future? Medicines and other products are novel and inventive, so it's really the person who puts together the information that's been provided to them by the Indigenous groups about medicines and other things. What I would tell people copyright doesn't protect are these things here. And when you look at things that I've got on this slide, that is really a lot of the work that Indigenous groups would do. So that's not protected by copyright. And I took this quote from Terry Janke, who is an Indigenous lawyer, and she's made Indigenous copyright, her main area of expertise. So she was talking about Indigenous cultural and intellectual property rights. And you can see that there it talks about intangible and tangible and being passed on. And that reinforces cultural identity. And with Creative Commons, I just took a standard definition of what that is from the Creative Commons website. And I think most people know what that is. I also looked at some of the benefits and disadvantages of Creative Commons. And in looking at the disadvantages, a lot of the work I read said it doesn't really answer that issue of copyright dominance. It sits like beside copyright, but there's still a lot of questions and a lot of issues about copyright. It also, I don't think, addresses the issue of what property is, particularly in terms of Indigenous thoughts and ideas about property. And it ignores the cultural concerns about the public domain. And with a lot of the work that I read, and I'm sure other people have read about Creative Commons and, you know, the greater good and stuff that's out in the public domain, there are still arguments about the way in which Indigenous information and knowledge was appropriated and continues to be appropriated in some circumstances because people were not considered part of the public domain, you know, particularly Aboriginal and Torres Strait Islander people in this country. So I said, you know, there's still some underlying issues that sit with Creative Commons about that definition of the public domain and whether the Indigenous creations really fit in there.
Yeah, when you look at the, Australian Indigenous people have had a bit of their, a lot of their culture appropriated, but nothing on the scale of, say, the American First Nations people, where they've, you know, Disney has mined, and all the big media companies have mined their culture, the so-called public domain, for content.
Yeah, yeah. So, you know, as a lawyer working with a client group to look at these things, my questions would be, what does the artist want to achieve? Do they want their artwork or whatever it is that they do to be out there in the global space? Is it something that they're doing to keep their stories and their culture alive and be able to pass it on to future generations? I think it's really clear to establish what it is that an artist wants to achieve. And is Creative Commons the best alternative for the client? And how does Indigenous intellectual property fit within that IP and open source debate? And is there something still missing? And I just sort of came up with a little, if we wanted to go down the road of Creative Commons, a little ABC of Creative Commons. So, you know, the artist with the idea brings that idea to the world, and then Creative Commons can help the artist to share the work globally. And I've got just a list of links, and particularly that first one with the Owsley from Murdoch University, that was quite a good article about, I'll just see if I can open it. No, sorry, can't do. But I'll put these onto the Moodle site anyway so people can have a look at them. I guess one of the other interesting things I found later in the piece that I was looking at was just in relation to a case called Berlin, B-U-L-U-N, versus R&T Textiles. And in that it said the court recognised that the artist owes a fiduciary obligation to his or her clan to ensure that the work was used consistently with customary obligations. So I thought that was quite an interesting case, and I'm going to explore that one further. And one of the sites I looked at, you've got Creative Commons and there was also Critical Commons. And could there be a cultural commons that holds, Indigenous knowledge-specific licences? So that's just something that I thought, we could look at and consider as well. So I guess that's what I've been able to put together. So I'm quite open to hear what people have to say or comments about that. And this is the trend. This is a kind of theme that I'll be exploring with my thesis as well. So I'll just stop the share. There we go. Oh, yes. That was a relief. But as I said, in looking at Creative Commons, it did raise a number of other interesting discussions and debates as well. So, all right.
Yeah, Creative Commons is one solution that works within the copyright system, but it certainly isn't going to be the only solution. So I think the points that have been raised in the chat window in terms of monetarisation and in terms of property are very, very interesting. The one thing I wanted to add is one thing that I think an examination of the Indigenous perspective around the world on Creative Commons really shows us is that many of the assumptions under copyright law don't hold true for Western culture either. That the idea of things like, the Men at Work case being a classic example of, can someone own a set of notes? Now, musicians have riffed off each other, played off each other forever. And an Indigenous perspective gives us apart from being a very important perspective of its own, but it also, when we look back on it, it makes a lot of our own Western assumptions seem very strange. And then we look at it and go, well, we don't believe that either. So why do we believe that copyright is the only way to go?
I was actually going to put some of that music in there and I thought, no, maybe that might open another set of worms if I played Down Under.
Other folks, how many notes a didgeridoo can play? I have a tin ear for music.
I'll have to ask that one of some of the experts in the community here, because as a female, I don't play it either. So.
One of the points I also thought was really interesting was copyright protects the expression of an idea in a physical form. And you mentioned the fact that stories in paintings aren't protected. I thought that was really, really interesting because we have a very literal idea of what a physical representation of an image is, of an idea is. And it's interesting, you push it just a little bit further and talk about something about the story that comes from a painting, and all of a sudden it's like, oh no, we can't protect any of that. I thought that was I hadn't seen that before. I think it's a really interesting point.
Thank you. So any other questions or comments or feedback? I really think this is an area that I'll probably have a bit more of a look at because, as I said, it kind of opens up a whole another world in terms of what you can look at and what people are talking about.
And honestly, when it comes to writing your assignment, your major assignment for this course, being as specific as possible is really good, as long as you're confident you've got enough sources, enough evidence to make your argument. So, and sometimes that requires a little bit of lateral thinking of saying, well, okay, I've got this case and I can, sort of squeeze it in sort of, as an analogy to the situation. But rather than saying, I want to look at the entire field in 2,000 words or whatever, being able to say, I want to look at something really, really specific is actually a really good way to go with these sort of papers.
All right. Well, thank you. but there are some interesting writers and whatever around now who are really getting into this subject. So, yeah. I've actually got a niece who's just started doing law and international relations at QUT, and she presented her paper in World Trade, and it was around IP and Indigenous issues. So, yeah.
When I started teaching IP law, which was, about 10 years ago now, basically last week's was the end of the course. It was really depressing. It was basically IP law has done all these things, but basically the world is dominated by US trade agreements, and IP is just going to be dominated by corporations from now on. And what's happened in the last 10 years is things like Creative Commons, Indigenous rights have come out of the debate, and we're actually, I think, in a really interesting, positive time where we don't end the course by saying, and Disney will control the world. We're actually looking at things like Creative Commons, looking at things like the Hit Record production company and saying, oh, the world is changing, and in a good way. Anyway, Kate?
Thank you. Right, well, I've looked at Creative Commons for musicians. So my PowerPoint's probably a bit more wordy than Margaret. And I didn't have a video, but I'll see what I can do. Hopefully it's not too boring. I'll try and get the screen sharing going. So if it's not working, let me know. Right. Can everyone see my PowerPoint? Right. So the first picture I found was a Creative Commons image, and how I found that will come up later on. So like we were saying, Creative Commons is kind of a new era of IP law, and the music industry has really changed with the internet and the way that we distribute music. So that's opened up a whole nother kind of can of worms with copyright. So traditional intellectual property doesn't allow for kind of sharing of music in the way we share it now, where people will go on YouTube, grab their favorite song, put some lyrics or some pictures to it, and upload it to share with people they know. Traditional copyright law will mean you'll get 1 of 3 strikes and it'll be taken down. So Creative Commons kind of helping musicians in that way if they choose to utilize it. So Margaret also touched on the Creative Commons organisation, which has been around for about 14 years now, and they actually draft a few licenses that people can download for free and apply to their work, whether it's music or art or literature or whatever they're going to do. So apparently now according to their website, there's 882 million Creative Commons licenses being used. Not sure how they came to that figure, but it is quite a lot. So when people are producing music, there's different kind of licenses they can go for. They can go for anyone can use it, I'm releasing it to the world, or they can say all rights reserved, which is kind of the main approach taken by record companies who want to protect their income stream. Or, as some people are turning to, you can go with Creative Commons, which is somewhere in the middle. So Creative Commons is a copyright that gives some rights to other people while still reserving others for the original content creator, and how much they give away is completely up to them. So it's a good way to manage, like I said, manage people's rights in relation to how the music's used and who can use the music. So there's 6 different kind of standard Creative Commons licenses, and the one unifying factor of all of them is attribution to the creator of the original piece, whatever that is. So the standard license, or the most open of them, is commonly referred to as a CC BY, which is the little icon up in the corner. That is a Creative Commons thing you can download from the Creative Commons website, and they encourage people to stick it on their website, put it on their work, because it's actually different levels of code that search engines can read. So you can, as I'll say later, you can actually search for things that have different licensing types. So the standard license allows people to distribute, remix, build upon work for commercial and non-commercial purposes. So that would be anything from sampling it into a piece of music and putting it in a song, or uploading it to YouTube, like I said before, with some pictures and words that mean something to the person. Or you could use it in a TV show because they've kind of put it out there for everyone to use. So they get a little bit more restrictive as they go along. So the next type is a share alike, which is the same as the first one. People can remix, build upon, do derivative works for commercial and non-commercial purposes, but any new work they create has to be licensed under the same terms. So not a music example, but Wikipedia runs off that kind of licensing where you can put information up, but people have to be able to share it. So you kind of don't own it. Once it goes up, you're releasing it onto the internet. The next one is a non-derivative license. So people can use it for commercial and non-commercial purposes, but they can't change it. So you can't take a sample of it. You can't use the beat or the lyrics. You have to kind of use it as one whole piece. So really the way the artist intended it to be seen. The next one is non-commercial. So you can use it, you can remix it, you can build upon it, you can distribute it in different ways, but only if it's a not-for-profit. So you can't use it in any kind of money-making enterprise. Like before, an attribution, non-commercial, share alike. So all these things are kind of individual blocks, I guess, that build upon each other. So you can choose to share it with everyone, but not if they're going to use it commercially, and only if they'll share it on again. So it's really a collaborative effort, I guess, is the best way to say if people are using this for creative things like music. We've also got something that's not commercial, no derivatives. So again, you can use the song, but only, or the piece of music or the lyrics, but only as a whole. So there's a few different licensing types that are available, but it's important to note it doesn't mean that people are giving away music for free. That seemed to be what I found people did a lot when they did a Creative Commons license. They would let people download it for free, but that's not always the case. And it seems to be a real kind of underground, new and emerging artists use it a lot because it's a really good tool for promotion. And when they don't have a big budget to, get it playing on the radio and send it out to different people, allowing the different, groups that hear it to then say, I like that, I want to use it in my project, or feature it on my blog, or build up a YouTube video, or put it in some kind of film or TV show or commercial that they're working on, is a good way to get your name out there.
Or using cafes, because cafes and restaurants have to pay hideous licensing fees to ARIA each year to play music. And you could just put on a net radio Creative Commons channel and not have to pay anything.
Yeah, so it does have a lot of positive benefits for the musicians. Also, a lot of songs that are released at the moment seem to be some kind of rap artist sampling some old song and remixing it all together. Usually they would have to pay the artist that it comes from, but if you've got a Creative Commons piece, it's a good way for people to show their skills and express kind of their message by finding works that they don't have to pay that exorbitant amount. So it really helps with kind of collaboration and the kind of global way we look at things now. It's not just, this is mine, and you can listen to it. It's more, everyone's involved, everyone can share and build upon it, which is kind of what the internet is allowing us to do. So it's probably why Creative Commons has come out more recently. So that Creative Commons isn't necessarily for everyone. In a piece of music, the music, like the notes and the composition, is one piece that can be licensed. The lyrics are another. who actually takes a recording of the two of them together is another thing altogether, and playing it live is another thing. So they can all be licensed separately. So before any musician would decide to license their work, they need to consider what part they actually own, whether they can release it all under a Creative Commons license, or whether they'd have to, just release the lyrics because that's what they wrote, or just release the recording if they're an independent artist. So I said public material is not copyrightable. So if you've used anything that's in the public domain as part of your song or your musical composition, that's not covered by it. And it's also possible to have different Creative Commons licenses on different parts. So like I said before, the lyrics and the music, any associated film clips or photos, they can all be licensed differently. So someone might choose to have the lyrics and the music available to everyone, but if someone wants to play their film clip, they are going to need to pay for that one. Also, once someone puts out a Creative Commons license, if you decide they get picked up by a major record label and they don't want that out there anymore for free, they can take it back, but if you've accessed it under a Creative Commons license, you're still entitled to use it under those terms. So that would probably be a consideration for people wanting to put work out under that way. It interestingly said if you breach some of the terms, the license ceases. So if someone said non-commercial use and someone has used it in a commercial way, they have 30 days to rectify that. And then they can have that Creative Commons license back. But if they don't do it within the 30-day time period, they have to expressly ask whoever owns the license if they can use it under those terms again. And you will be responsible for any damages in the period where you were notified that it wasn't used in the right way. So it really, I guess, takes a proactive approach to see how your material is being used and whether it's within the terms of your license, because as much as we'd like to think everyone would just listen to what the licensing says, we all know that's not true. So I found a band, Nine Inch Nails, not someone that I listen to, but from what I've heard from other people, a well-known band that have actually released 2 albums under a Creative Commons license. So they had one that came out in 2008, which was a attribution non-commercial share-alike license. And later that year, they released another album under the same licensing scheme. So on their website, they have a section where fans are encouraged to post remixes that they've made of the songs. So they want their fans to kind of become part of the musical process and take what they've got and build upon it and share it with other fans and grow their fan base. It's interesting that some people pointed out that they thought it was going to be a big disaster. What are they doing? They're giving it away for free, because they gave away 6 songs for free on one of the albums, and you could buy the other 30 songs. But that album, which was called Ghosts, went on to become the most downloaded album of 2008. And in lots of the little comments on iTunes, people were saying they'd sampled it, like listened to the free stuff or heard someone else play it somewhere, liked it, were kind of impressed by the fact that they could use it, and that was an incentive for them to go out and actually buy the album. And the second album they released under the same licensing scheme had a tour supporting it that was a sellout. So it could be seen by some people as a loss of income streaming to put their things out under a Creative Commons license. But it's a different tool. I guess you could look at it as a different way to get your music out there to fans, and then hopefully they'll want to come and see it live and buy the album or buy any of the merchandise or accompanying items, which is how a lot of musicians are actually making their money on making their money now because of things like free downloading and YouTube, and I think it's an old one, but like LimeWire and all those kind of ways that people share music that's illegal, but everyone does it. That doesn't mean it's right. So generally speaking, when someone does have a piece of music they create, it is covered under the Copyright Act straight away, so they don't need to apply for a special kind of license. But if they want to use a Creative Commons license, then they'll need to attach that to their piece. But it's also free from the Creative Commons website. So like on the Nine Inch Nails site, it has a little blurb down the bottom that says their music is available under Creative Commons and links you to a full legal document about what you can and cannot do with it. Some interesting other resources were the Creative Commons site, which is a non-for-profit organisation which drafts licenses. And if people aren't sure which one to use, they've got a little interactive license chooser. So you can say whether you want it to be used commercially or non-commercially, or you don't care. Either way, and it'll step you through and recommend a license at the end. Also, Google has an interesting search function that you can use in the advanced options. You can go to usage options, and there's a drop down that allows you to filter by license types. So you can filter by things that are available for you to use commercially or non-commercially, or for you to share, or that you can build upon, which I didn't know about until this, and that's how I found all these images. They're all Creative Commons images from Google. There's a little record company called Records on Ribs, which is a record label that releases digital music free under Creative Commons licenses. So it's just a new take on music distribution. Although, interestingly, their logo is not something you can download under a Creative Commons license. So I can't get a picture of that. And the last little place is a new social media platform called SoundCloud, where all the music uploaded is original music, and it's licensed under a Creative Commons license. So it's a bit of a pool for people to go to and take music from and build upon it. So it's kind of showing a more collaborative approach to music and to art and all those kind of issues, which is not what we had in the past. It was very strict, and people would go after and protect their copyright, which is fine. But now it's a little bit more of a, it's reflective of the internet and how the internet has changed how we share things and communicate, and how people want to take things and have their input and put it out there. So yeah, that's all I had really.
Music has really been at the forefront of all of this, I guess, because of it was one of the first things people started sharing digitally once the internet got hooked up. But the other thing was you started having artists reacting to the control that music companies had. And I remember it was quite shocking when Ice-T, who for the young people out there used to be a musician, wasn't always an actor, with a band called Body Count, which is about from the same era as Nine Inch Nails, which is, I guess, my era. And he revealed that I think he made 10 cents for every CD that the record company sold, and the rest of the money went to the record company. And people then began to realise that musicians, even though particularly the rap artists who, were covered with diamonds, driving in limos and everything else, and flaunting their wealth, weren't actually making most of the money that was to be made out of their product. So I think that consciousness changed the way we saw things, because before then people fairly naively went, oh, $30 for a record, I bet maybe $10 of that goes to the artist, or $20 for a book, I bet maybe $10 of that goes to the author. And what's been exposed through all of this is the little amount of money that creators actually make from what they create, and you've got to be J.K. Rowling to actually make any money out of it. And then looking at alternatives, and a lot of the internet has provided things like, Nine Inch Nails have such devoted fans that Trent Reznor could just put out an album of him flushing the toilet, and people would all rush out and buy it, even though it was being made available free as well. So it's a real difference between this idea of there being artists and creators and record companies and these, fans being these people who are passive consumers. And you really pointed out how that relationship's changing. The relationship between being a passive consumer and being interactive is really changing. So, yeah, it was a really interesting thing to point out.
It was interesting when I was reading about, particularly Nine Inch Nails is probably the most well-known group that I could find. And in one of their interviews, they actually said they felt like it was giving back to the fans. They didn't feel like the music should be kind of inaccessible, I guess is the best way to say it. They felt like fans should be able to use it and enjoy it and put it into things that they love because they were making music for the fans and not a record company, because they put out their Creative Commons albums just after they split with their record company.
Yeah, and I think, Brendan, you're right. I think Radiohead did. And at the completely other end of the music spectrum, Grateful Dead have always been allowed fans to record concerts live and so on. And weirdly enough, Metallica used to. I remember, this is when I was a teenager, there used to be a section at Metallica conferences where they would have security who would look after your Walkman if you're taking your Walkman in to record the concert. And then Metallica found out about Napster and Lars lost his mind, and they became kind of the laughing stock of the internet world when they tried to sue the internet. And so on. But yeah, there's definitely all sorts of different bands out there. And I think you're seeing a real difference between mass consumption pop music, where all they really want to do is sell their single for 99 cents on iTunes, and the sort of in-depth, beloved fan artists, whether they're as big as Nine Inch Nails or whether they're sort of local bands.
Well, a lot of the music on YouTube, if like a 14-year-old girl puts up a Taylor Swift song with pictures that she loves, then there's a lot of stuff I found in researching about this, how then YouTube will like swoop in, take it down, and they get a strike against their name. So it's kind of creating like an us and them, like it's our music. You can just listen to it if you pay for it. And these other people are kind of being a little bit more collaborative and putting it out there, which is really getting them a dedicated fan base, which if they market it in the right way, they can actually translate into an income stream for themselves. So it's not just about people in their garage giving away money for free, which is probably what I first thought when I started looking at some of these things.
And it also opens the ability to, because particularly with the commercial, non-commercial licenses, you can share a song for free. And if someone in the ABC production office, and this happens with the ABC because they have an obligation to use local Australian music. So artists put things out there and share them freely. And the ABC says, we want to use this in an episode of a drama. And then they pay the artist, and they pay the artist a lot of money compared to what artists are used to getting, just to use the song in one of the TV shows. So rather than trying to keep your copyright and retain your copyright and not have make fans pay for it, I know a few local bands have actually been quite successful giving everything away and then having this income stream coming from production companies.
Mm.
Yeah, that's the what Kit's saying. The reason the monopoly existed with the publishers is because there was just, and it must be. I was 24 when the internet happened, and I was around on bulletin boards and things a little bit before then. So I have a foot on each side of it. But it must be, I think, really weird to have grown up with the internet, to actually cast your mind back and to think about the era where, if you wanted something, you had to go and find a physical copy of it. That must be a really strange sort of thing to think about when you're not used to it.
I think it's interesting on a few of these sites, like the Nine Inch Nails actually had like a dedicated fan section where they said, like, we encourage you to share our music with your friends and your family and anyone that you know. and have a play around with it and upload it to the site. And they were running competitions that have long since finished, but running competitions to see who could come up with the most inventive use of their work, which is something that people were probably doing that before the internet, but they would be doing it with a tape player and a mixing thing. And it was all very private and you didn't share it with the world because you couldn't really, but it was illegal to do that. Kind of the days of pressing record and playing and recording from the radio were one way that people got it. People are always going to get it. People are always going to find a way. So it's bands like this that are embracing it and saying, just have it, and then trying to find another way to turn it into revenue, whether it's not licensing it for commercial so people have to pay for it, or they're broadening their fan base so more people are like, I heard that, I love that, I want to go see that concert. It's kind of a whole new world with music and art and television and all those kind of creative things.
I realise I've sort of suggested you have a look at Hit Record as well as part of this. And again, the same way that Nine Inch Nails, I mean, they're high profile compared to, I guess, to others, even if it's new to, not everyone knows about them. But Nine Inch Nails were quite a proponent in the early days of Creative Commons. With Hit Record, Joe Gordon-Levitt is, as a fairly well-known actor, leading the charge on open production. And what they do is they don't Creative Commons license, they share, and then they pay people for what they use. So they don't create things and produce them on a Creative Commons license, but they use a kind of a variation on it. And if you get a chance to ever see any of the Hit Record TV shows that they've done, they're just as interesting and good as and they're all themed around these different projects that are put together from other people's work, and they're really interesting, and they're perfectly professionally produced and everything else. So yeah, when we're in a world where I guess we're moving on one side to more and more mass-produced cheap reality TV like My Kitchen Rules and The Block and everything else. And on the other hand, this potential for people to actually be really actively involved in creating media. And I don't know that one's going to take over from the other, because there's always going to be a need for veg-out TV and that people don't want to be interactive with. But there's also this emerging field. And law is helping it happen, which is remarkable.
I think that's what I was, was realising too, was that there's the role of law in this, and how law can work with the artists and, with whole sections of the community to work out what's happening, where it's happening, what is it that people want. People can put a little toe in the water and just see how that works for them, or they can jump in fully, or they can disregard it. But law and lawyers are sort of stepping into that area more, and it's not black letter stuff anymore.
I've been reading a book that Stevens actually, the head of program, has suggested to me, called Tomorrow's Lawyers by Susskind. And it's a couple of years old now, but it's recent enough that he's projecting what's going to happen to the legal profession. And he's saying that the old sort of barrister, solicitor roles are disappearing. They've already begun to disappear. And what we're going to have is, in the next few years, really different sorts of lawyers emerging. And a lot of their work's going to be interdisciplinary, and a lot of the work's going to be situated in various contexts. And he doesn't really talk about IP lawyering, but to me that's a classic example of something where the idea of going and seeing your IP lawyer and sitting in their office and them going through that role isn't really existing anymore. I mean, there are people who maybe will work for big media conglomerates as in-house lawyers that'll still have a bit of that role, but the IP lawyers of the future are going to be lawyers and creative at the same time. So I found that book kind of inspiring, and we're sort of working on, given how different our degree is, actually trying to amalgamate some of that stuff into it and actually look at, whereas, even big law schools like Melbourne Uni are looking back to the 1960s and the 1970s as the glory days of lawyering, in the vague hope that one day we're going to turn back the clock and we're going to go back to the old days. what Susskind is saying is the old days are gone. Law schools are preparing everyone for jobs that no longer exist. We need to prepare people for the jobs that are coming. So I find that pretty exciting, but I understand that not everyone else finds that terribly exciting. But yeah, as a media lawyer, it really strikes a resonance with me.
It's probably interesting, just with what we're saying, that this is really on the forefront of how things are changing. Usually you think of law as lagging way behind and being very like set in stone that this is how you do it and you have no options. It's just kind of interesting to note that this is giving people the opportunity to really take the law into their own hands and decide, how do I want to let people use what I've created? And it's probably a good thing that it's moving that quickly, because we always hear about the laws are slow moving machine. So I think that's just really struck me, just with what we've been talking about here, that it is moving quite quickly. And that's probably the way of the future, that things are going to change and law needs to keep up quickly if it still wants to be relevant.
Lawrence Lessig, who we've touched on, his work has touched on throughout this course, who really did kind of invent Creative Commons, is a real rock star lawyer. And really, it's that turnaround point of the lawyer being someone who just says, you know, a computer says, no, you can't do it. No, that's all too risky. No, that's wrong. To a lawyer who goes, hang on, we can build something out of what we've got. We don't have to just stick with saying no. We can find ways of saying yes. And I mean, he does lecture tours from time to time, and he's moved on from IP law and he's looking at congressional reform or something, which is, I don't think is interesting to me, because I'm not American. But if you ever get a chance to see Lessig talk or to have a look at some of his talks on TED Talks or whatever, he's really inspirational, and I think he's a great person to hold up to someone who's looking at a career in law, even if you go for a more conventional path, to say, here's someone who's a role model. I mean, he has been for me.
One thing I've noticed, and bothers me a little bit, but we've reached the end of the course now, is how completely incapable the law seems when it comes to dealing with the existence of the internet. Like we were talking about music today, and it just seems like the current legal framework in place is fantastic if we were dealing in the days of the Walkman. But, you know, with the existence of the internet, it just seems unrealistic and, you know, honestly ridiculous to think that the current IP laws can be relied upon by, you know, musicians or publishers or whatever in trying to enforce their creative rights. So in saying that, I mean, what should the law of the future when it comes to IP look like when it comes to dealing with the internet? I actually don't have any idea how the internet can be dealt with by the law, and I'd love to hear what your thoughts would be on how possibly the law should look.
Interesting. There's a few layers to that question. One thing I think is an interesting thing to start with in terms of regulatory theory is we always look at incomplete regulation as a failure. However, you look at the sort of the oldest form of regulation we have, and it's probably criminal law. And you don't give up on criminal law by saying, well, people are still being assaulted out there. We can't stop people being assaulted, therefore we shouldn't have criminal law. I mean, there are plenty of flaws with criminal law, and we're constantly trying to find ways to fix it and to fix the systemic injustices in it. But we still persevere because the fact that it doesn't fix the problems isn't really the issue. So there's this idea of regulatory incompleteness that doesn't necessarily hold over to other areas of law. And one of the best things I did was I diverged from law for a few years when I graduated and became a criminologist and worked in a criminology school. And it suddenly made me, even though crime isn't something I have a real great interest in, it really made me look at some of it's the most theorized area of law. And with criminology, you had sociologists, psychologists, lots of disciplines looking at it. So criminology is interesting in terms of what it tells us about regulation. So yeah, the first thing I would say is incompleteness isn't necessarily a problem. We have to look at what we can do with the tools that we've got. The other thing is we're still living with sort of every generation thinks that the next generation is insane, and next generation thinks the previous generation is stuffy and immovable. But we do need good, capable IP lawyers and IP academics and social commentators moving in the field, because there are things that, unless you grow up with and you're part of that culture, you just don't understand. Marshall McLuhan talks about the idea of, he calls it rear view regulation. And that's the idea that you regulate something on the basis of something in the past. So mobile phones, when they were invented, were regulated as phones. Then the internet came along and we said, is it a phone or is it a mail system? And we basically used old metaphors to try and regulate, because it was things we knew trying to evolve and adapt. You need that two-way conversation. And as I said before, if you've grown up with the internet, a lot of the things in the pre-internet culture will seem mysterious, because you don't really get what it's like not to be able to just get online and access a song when you need it. By the same token, if you're not part of that culture, it's like watching some of my colleagues try and use social media. Bless their little hearts, they try. But they get a Twitter account and they post a tweet and they wait for the world to come to them, because I'm out there, I'm on Twitter and I've got 5 followers, including my family. I'm out there, I'm using social media. And it's like, unless you're immersed in it, you can't understand it. So you need those dialogues, and you need that kind of, you need that sort of stuff going forward. So yeah, I mean, I'm in a weird position because I sit on both sides of the fence. But I also have to be aware that I'm going to be, things that are going to come out. And it's like, what's Tumblr? What's that? Is that just Facebook or whatever? And I need to be sort of keeping up with that. So yeah, I think there's need for more young voices in the field. And also the old voices, and there needs to be conversations. Corporatization of creativity and innovation. Kit's pointed out the doco on Lessig and Aaron Schwartz. Yeah, that's really interesting. That's really worth a watch. Grant, I don't think corporatization, it's a bit of a, has some sort of negative connotations. But yeah, it's sort of about...
I certainly do in a negative way.
Yeah. It's also, though, about building business systems to help creative people, because I don't think it really helps when people go, oh, look, I'm creative, I don't know anything about money, I don't know, because that sort of is, people just get exploited then. So, again, it's a left brain, right brain thing. I think you need people who are creative, they've got the right brain stuff, but also left brain enough to know how to organise themselves. Monetizations sounds horrible, but you need to figure out how you're going to feed yourself while you're doing your creative career, even if it's just working in JB Hi-Fi, which every musician in the world seems to be working at. But understanding the sort of those practicalities, I think is good as well. Yeah.
My position is that creative people should be protected. They need to be able to secure their income stream, because if they're not, gaining a profit from what they're creating, whether it be art, literature, or music, then unfortunately they'll probably just stop doing it if for no other choice, and they have to do something else in order to survive, which is going to be, a shocking loss for all of us as a culture. Should we not have protection for these people. But at the same time, I see, greater and greater opportunity for people to, I suppose, exploit their work and them to get nothing from it. I mean, this discussion tonight about Creative Commons is a great example of how things can go well once they have, someone has a following and people who know who they are. But it also, I suppose, opens up people to the tragedy of basically being exploited and somebody else profiting from their creativity, like the In the Jungle song from The Lion King. So
when you think about
I suppose,
the Statute of Anne, the very first copyright piece of legislation, the reason it existed was because the Stationers Guild, owned all the printing presses and they were printing people's books and not giving them any money for it. So this idea that you brought up about exploitation has been in the thing the whole way through. Yeah. And Charles Dickens has said some great things about America and the fact that America was a nation of pirates, because basically everyone in America just printed copies of his books and he never saw any money for them. So, yeah, the whole history has been about that balance between enabling and protecting individuals, but also stopping the rapacious corporations and the owners of capital coming in and just stealing stuff. And, you know, in the Indigenous art area, people printing off thousands and thousands of T-shirts with Aboriginal designs on them because they think no one owns them and they can do that. Yeah, there's an important role of protecting individual and collective creative groups there.
So when you talk about the protection of individuals, so the individual creator, the person who writes the song, the person who, I'm just going to focus on music for now.
Yep.
But it's relevant to script writers for movies and you name it. But like you say, when you have musicians who are working at JB Hi-Fi just so that they can feed themselves and of course, you know, they may have a love of music, but the fact is when they sit down with a music exec and he says, look, if you don't fit this particular profile, this music is fantastic, whatever, we'll give you $400 for it outright, or $1,000, or, you know, maybe $10,000 if it had to be particularly good. But then if that becomes like a top, you know, 10, top 100 on the Billboard charts in the US or whatever the case, those record companies, the corporations, make squillions of dollars, but the actual creator of the music, the person who had the genius to create it, they may have just got a few $100s out of it. And that to me is the reality. And that's why sort of the more I've sort of been sort of working through this course, it's more sort of bringing together a lot of those things that I guess I've always sort of felt a little bit, but haven't really sat down and thought about it too much. Where now I'm sort of seeing the disadvantages to the creators and the disadvantages that it has to sort of creativity and innovation, and that includes with patents as well. It just seems to be that reading these articles and about the lobby groups and how the lobby groups are backed by obviously the corporations and they push the government to make change, and all in the name of the artist, but in actual fact it's not in the name of the artist, it's in the name of their profits. And that just seems to be counterproductive in terms of the purpose of IP. IP is sort of, you know, meant to protect the creation of new, you know, works and whatever, but it seems to do the exact opposite.
And I think, you know, you mentioned in passing things like patents as well. I doubt whether there are very many situations where the old idea of the patent being the brilliant inventor comes up with something and they patent and they make money out of it. I mean, these days, patents are all people working in pharmaceutical companies. And if you are a brilliant scientist and you come up with a new pharmaceutical, generally you don't get anywhere near the patent for it. That's just part of your job as to what you do. So yeah, any system that's set up to reward individual brilliance tends to be taken over by the corporate interests. But I was hoping that maybe this week we will have a little bit of balance and a tiny bit of sunshine in the gloom as well. Because honestly, as I said, 10 years ago when I started teaching IP law, this was the point. The point we ended at was basically it's all become corporatized and Disney will own everything, and you know, that's the end of the story. And we've actually seen some progress since then. And on music, there's an interesting little doco piece that John Safran did with the New Zealand pop stars. I mean, who are, you know, if you don't know, it's worth having a look because it looks at what happens to people who even are produced artists who people presume are making lots of money out of the music, and then when they get discarded by a record company, what happens to them?
It seems like it's been a bit of like IP and everything, is a bit of a power struggle between people who want to make money off it and the people that want to leverage it into something, and the people that came up with it. But it seems like Creative Commons and open source is kind of a way for people to take some of that power back and say, I'm going to choose how it's used. And then that gives them an opportunity to turn it into something more than just a money-making exercise for someone else if they play their cards right.
Yeah. Yeah. I mean, I'm conscious of the fact that we've gone over time and people may have places to go and families to talk to and everything. But it's been a great discussion, guys. Really interesting. And I think a good place to end the course on a very positive note. Bittersweet when we do realise that there is all sorts of defects and flaws in the system as well. But I hope the little tiny journey we've had this term has at least been interesting and opened things to think about and things to go forward with. As I said, I'll be online next week for discussions, and I'm sure by that point people will have questions about their essays and things, or they may be all happy and ready to go and ready to submit, and there won't be any questions. But I will be here anyway, just in case. So
yeah, well, just thanks to you too, Scott. It's been a really interesting course and something different to what I've had for the last 2 years. So thank you very much.
Thanks, guys. Try to make it interesting. I get bored. If it's too boring, I get bored. So it's all totally self-motivated. If we spend too much time just looking at cases and legislation, I find I'm bored myself. So I like to mix it up a little bit. Okay. I'll stop the recording for now and close this session.